fan fiction. Maybe you read it, maybe you write it, maybe you lie awake at night terrified that the cringy, angst-ridden Final Fantasy story you wrote back in the 10th grade might still be out there. But one question has always hung over the fanfiction scene. Is this stuff actually legal? Well, in this video, we'll try to get to the bottom of the issue, but before I go any further, I must offer this disclaimer. I am not a lawyer, and nothing I say in this video should be taken as being authoritative. If you take anything you hear in this video as actual legal advice, well, let's just say that you probably deserve whatever happens to you. Second, I am not an American, but I will be focusing on the laws of the United States, as that is likely where most of my viewers reside. So, with that out of the way, the question of whether fanfiction is illegal or not hinges on whether or not it constitutes a violation of copyright. But what is copyright exactly? Simply put, copyright is a form of intellectual property that gives a creator the right to, well, make copies of something. But that's not all it grants you. One of the foundations of copyright law is something called the Berne Convention, or more fully, the Berne Convention for the Protection of Literary and Artistic Works, which was a convention held in Bern, Switzerland in 1886 in an attempt to establish what sort of rights authors had to their works. Specifically, it laid out that authors had a right to translate a work, to make adaptations and arrangements of the work, to perform in public dramatic, dramatico-musical, and musical works, to recite literary works in public, to communicate to the public the performance of such works, to broadcast a work, to make reproductions of a work in any manner or form, and to use the work as the basis for an audiovisual work, and the right to reproduce, distribute, perform in public, or communicate to the public that audiovisual work. The Berne Convention has been ratified by nearly all nations on Earth, and if you look at the United States copyright law, you'll see that it basically offers the same sort of rights to authors. Specifically, the owner of a copyright has the exclusive right to do and to authorize any of the following: to reproduce the copyrighted works in copies or phonorecords, to prepare derivative works based upon the copyrighted work, to distribute copies or phonorecords of the copyrighted work to the public by sale or other transfer of ownership, or by rental, lease, or lending. In the case of literary, musical, dramatic, and choreographic works, pantomimes, and motion pictures, and other audiovisual works, to perform the copyrighted works publicly. In the case of literary, musical, dramatic, and choreographic works, pantomimes, and pictorial, graphic, or sculptural works, including the individual images of a motion picture or other audiovisual work, to display the copyrighted work publicly, and, in the case of sound recordings, to perform the copyrighted work publicly by means of a digital audio transmission. Alright, I know that was a bunch of blah 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 that you probably tuned out of. Welcome to the world of legalese, where everything takes 50 words to say what could be said in 5. Now, it's important to note that copyright protection does not extend to ideas, merely certain expression of those ideas that have been fixed, that is, expressed in some permanent form, such as a book, a movie, an electronic document, a photograph, or a sound recording. This protection comes into force the moment that an idea is fixed in such a manner, without the author having to apply for or register a copyright. For example, here is a photo I took at the zoo of a cute little prairie dog. The moment I took that photo was the moment I was granted the copyright to it, which means that if you were to use this photo in a video on YouTube without my permission, then guess what? You just infringed on my intellectual property rights. Now, I don't care if anyone uses this picture, of course, but I could potentially make trouble for someone who did so. Here's another example. Suppose I were to create a TV show about a starship exploring strange new worlds, seeking out new life and new civilizations, boldly going where no man has gone before. That would be perfectly fine because, again, ideas cannot be copyrighted. But if the starship is the USS Enterprise and its captain is James T. Kirk, then I would soon be receiving a call from Paramount's lawyers. To give you an idea of something like this happening, back in 2009, a bunch of people got together to make a Legend of Zelda fan film called The Hero of Time. Despite the film being available at no cost, and the filmmakers adding a disclaimer that it was in no way endorsed or authorized by Nintendo, the Big N was not appeased and shut the film down with a cease and desist letter. Before we go any further, however, I want to distinguish between a copyright and a trademark, as they are sometimes confused. A trademark is a sign, symbol, logo, or name that is used to identify a particular product, service, or company so that it will not be confused with another. Continuing with our gaming examples, the character of Mario and the whole Super Mario Bros. Setting is copyrighted, but the name Super Mario Bros. Is trademarked. Now, going from everything I've said, it would appear that writing and posting fanfiction constitutes copyright violation, in that you are using someone else's setting and characters without their permission, regardless of whether or not you earn money from it, or if you post one of those "I do not own" disclaimers. So it's an open and shut case, right? Well, maybe not. You see, copyright law has a provision that allows for the legal use of copyrighted material. This is known as fair use, or as it's called here in Canada, fair dealing. It's important to note that fair use is not a get-out-of-jail-free card. You cannot simply declare something to be fair use and make yourself immune to legal action. Instead, whether a work is considered fair use must be decided by a court on a case-by-case basis. U.S. law describes fair use as the use of copyrighted material for the purpose of criticism, comment, news reporting, teaching, scholarship, or research. The criteria for determining if something falls under fair use include the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for or value of the copyrighted work. In plain English, if you borrow copyrighted material in your works, then the court will want to know why you're borrowing it, what sort of thing you're borrowing from, how much you've borrowed, and how much financial impact your borrowing will have on the rights holder. A key element in determining fair use is whether or not the potentially infringing material is transformative. That is, it has taken the original material and transformed it into something new and distinct, which cannot substitute for the original work. An example of a transformative work would be a film review that uses several clips from a movie. The review is a criticism and a commentary on the original film, not the film itself, and it has taken the material from the film and transformed it into something wholly distinct. And the common argument for the legality of fanfiction is that it is transformative. In fact, there is a group called the Organization for Transformative Works that performs legal advocacy for fanfic authors and also maintains the fanfic website Archive of Our Own. So, is fanfiction transformative? Well, I don't know. I am neither a lawyer nor a judge, and what's more, I'm not sure that it's possible for anyone to make any kind of blanket statement about the legality or transformative qualities of fanfiction because, as I just said, fair use is determined on a case-by-case basis. My layman opinion is that any piece of fanfiction is more likely to be considered a derivative work than a transformative one. U.S. copyright law defines a derivative work as a work based upon one or more pre-existing works, such as a translation, musical arrangement, dramatization, fictionalization, motion picture version, sound recording, art reproduction, abridgment, condensation, or any other form in which a work may be recast, transformed, or adaptive. And who holds the rights to prepare derivative works? Surprise, surprise, it's the copyright holder. Now, as far as I know, there has never been a case of someone being sued or going to court for posting fan fiction on the internet. But perhaps there are some other cases that are somewhere in the same ballpark. The first is Nichols versus Universal Pictures Corporation. Ann Nichols was a playwright who wrote a play called Abbey's Irish Rose, which was a comedy about a Jewish man marrying an Irish Catholic woman against the wishes of their families. Some years later, Universal Pictures made a film called The Coens and Kellys, a comedy about an Irish man marrying a Jewish woman against the wishes of their families. Ann Nichols sued Universal Pictures in 1929, claiming copyright infringement. She lost the case, then appealed to the Second Court of Appeals, where she lost again. Judge Learned Hand, yes, that was his actual name, ruled that two works sharing similar ideas was not enough to constitute copyright infringement, stating that, If Twelfth Night were copyrighted, it is quite possible that a second comer might so closely imitate Sir Toby Belch or Malvolio as to infringe, but it would not be enough that for one of his characters he cast a riotous knight who kept wassail to the discomfort of the household, or a vain and foppish steward who became amorous of his mistress. This would be no more than Shakespeare's ideas in the play, as little capable of monopoly as Einstein's doctrine of relativity or Darwin's theory of the origin of the species. Now, this does not pertain directly to fanfiction per se, but it does concern an important question of whether or not fictional characters can be copyrighted. Judge Hand stated regarding Anne Nichols, "It is indeed scarcely credible that she should not have been aware of these stock figures, the low-comedy Jew and Irishman. The defendant has not taken from her more than their prototypes have contained for many decades." In other words, the characters in Abbey's Irish Rose were so thinly developed, mere prototypes, that they were not subject to copyright. And this is important for our next case, Anderson vs. Stallone. In 1982, a man named Timothy Anderson watched the film Rocky III and then sat down to write a 31-page script treatment for a sequel titled Rocky IV. In October of that year, Anderson met with Art Linkletter, a member of MGM Studios' board of directors, who then arranged a meeting with Freddie Fields, the then president of MGM, to discuss the possibility of using Anderson's treatment for the upcoming Rocky IV. According to Anderson, he was promised big money if they used his stuff in the movie. On July 12, 1984, Sylvester Stallone went on the Today Show to describe his plans for Rocky IV. Anderson claimed that his friends and family then called him up to inform him that Stallone was telling his story on television. Anderson eventually brought a lawsuit against Stallone and MGM, and the court ruled that Anderson's script constituted an infringement of copyright. More importantly, the court ruled, citing Nichols versus Universal Picture Corporation, that characters can be copyrighted, provided that they are developed with enough specificity so as to constitute protectable expression, and that the Rocky characters are one of the most highly delineated group of characters in modern American cinema. By this measure, Anderson's script was ruled to be an unauthorized derivative work. So, now we're getting somewhere. Specifically, we've established that using characters created by others without authorization is a violation of copyright, provided that these characters are sufficiently well developed as to be distinct from simple stock characters. Our next case is Salinger vs. Colting. If you went to high school in the US or Canada, then chances are good that one of your English teachers had you read J.D. Salinger's classic coming-of-age story, The Catcher in the Rye. Well, in 2009, Swedish author Fredrik Colting, writing under the name of John David California, published a sequel to The Catcher in the Rye, titled 60 Years Later, Coming Through the Rye, and Salinger filed suit for copyright infringement. Colting argued that his work constituted fair use, but the court determined that this was not the case as it made no commentary or criticism on the original work. Specifically, they stated that, while 60 years may, as defendants assert, accentuate and comment upon Holden Caulfield's naivete, depression, loneliness, absurdity, and inability to grow and mature as a person, because these characters were abundant, perhaps even central to the narrative of Catcher, this aspect of 60 years does not add something new, with a further purpose or different character, altering the first with new expression, meaning, or message. They went on to say that, nor do the mere facts that Holden Caulfield's character is 60 years older and the novel takes place in the present day make 60 years transformative. As the Second Circuit clearly noted in Castle Rock, just because a work recasts, transforms, or adapts an original work into a new mode of presentation, thus making it a derivative work under Title 17, Section 101 of the United States Code, does not make the work transformative in the sense of the first fair use factor under Campbell. So, what was that Castle Rock bit about? Well, it refers to Castle Rock Entertainment vs. Carroll Publishing Group Incorporated, a 1998 copyright infringement case centered around a book called the SAT, or Seinfeld Aptitude Test, a Seinfeld trivia book written by Beth Golub and published by Carroll Publishing Group. Eventually, Castle Rock Entertainment, the rights holder for the show Seinfeld, filed a lawsuit claiming copyright infringement. The case revolved around whether or not the Seinfeld aptitude test constituted fair use, and the defendants argued that it was a transformative work. Specifically, defendants claim two primary transformative qualities of the SAT. First, as noted by the district court, a text testing one's knowledge of Joyce's Ulysses or Shakespeare's Hamlet would qualify as criticism, comment, scholarship, or research, or such. The same must be said, then, of a text testing one's knowledge of Castle Rock's Seinfeld. Second, defendants style the SAT as a work decoding the obsession with and mystique that surrounds Seinfeld by critically restructuring Seinfeld's mystique into a system complete with varying levels of mastery that relate the reader's control of the show's trivia to knowledge of and identification with their hero, Jerry Seinfeld. Unfortunately, the court wasn't having any of it, ruling that any transformative purpose possessed by the SAT is slight to non-existent. In other words, you cannot simply take protected elements from a work and place them into your own work and then claim that it's transformative. Alright, one more case before we finish. The Tolkien estate versus Demetrious Polychron. This is one you may have read about in the news. In April of 2023, a guy named Demetrious Polychron filed a lawsuit against Amazon, claiming that their TV series, The Rings of Power, had infringed on his copyright for The Fellowship of the King, his fan sequel to The Lord of the Rings that he had published through his own company, Fractal Books. Now, it doesn't take a lawyer to realize that Mr. Polychron's case didn't have a snowball's chance in hell of succeeding, and the case was dismissed. Things got worse for Mr. Polychron when the Tolkien estate, who hold the rights to all of Professor Tolkien's works, fired back with a lawsuit of their own. They argue that the Fellowship of the King was a willful and blatant violation of plaintiffs' copyright interests, and that, as the copyright owners, Professor Tolkien, and now the Tolkien estate, have the exclusive right to prepare, authorize, and/or restrict the preparation of derivative works based upon Tolkien's canon, including the Tolkien trilogy. The plaintiffs argued that the defendant's novel contained a duplication of plot, themes, structure, dialogue, mood, settings, pace, characters, and sequences of events from Professor Tolkien's original work, including copyright-protected characters, such as Samwise, Tom Bombadil, Aragorn, Arwen, Legolas, Gimli, and others. The court agreed with this conclusion, stating that no rational jury could find that defendant did not actually copy the plaintiff's work. The judge then issued a summary judgment order prohibiting Mr. Polychron from copying, selling, distributing, performing, displaying, or otherwise exploiting his book, The Fellowship of the King, along with any other derivative works based on material by Professor Tolkien. He was also ordered to destroy all copies, physical and electronic, of the infringing work within 10 business days and then file a declaration with the court confirming that he had complied. You know, for that little extra bit of humiliation. Now, I can already anticipate a major objection to all these examples, which is that none of them involved actual fanfiction per se, because many of the authors in question were selling their works, and fanfiction isn't sold. Demetrious Polychron, for instance, was selling his Lord of the Rings sequel, and in the fanfiction community, it's generally considered bad form to try and make money from your works. In fact, sites like Patreon specifically forbid creators from earning money off of others' intellectual property. But the thing is, would any of this matter to the courts? An infringing work does not magically become non-infringing just because it's available for free. Nothing in the copyright legislation I've read states that copyright applies only to commercial material. The fair use test does consider the impact on the marketability of the copyright holder's work, as well as whether or not something is for a commercial purpose, but to quote the US Copyright Office, this does not mean, however, that all non-profit, education, and non-commercial uses are fair, and all commercial uses are not fair. So once again, just because fan fiction isn't being sold doesn't make it legal. I have to emphasize this because a lot of people seem to be confused on the matter. But this raises the question of why don't rights holders go after fanfiction authors? Well, consider that Legend of Zelda fan film I mentioned earlier. Nintendo was able to get it taken down because it was just one film. With fanfiction, however, there are hundreds of thousands, if not millions of works out there, and more are getting added each day. It's simply not worth the time, money, and effort for companies to go after every single fanfic author. Not to mention the fact that writers of fanfiction tend to be the greatest devotees of a work, and making legal threats against your biggest fans is a poor look from a public relations perspective. So if you're a writer of fanfiction, then you probably don't have to worry about getting any cease and desist letters. provided you don't do anything stupid like trying to sell your stories for profit and attracting the attention of the rights holders. Back in 2013, Amazon attempted to create a legal space for fanfiction with Kindle Worlds, which would allow authors to publish their fanfiction on the Kindle store and receive between 25 and 35% of the profits. However, authors had to abide by certain restrictions, such as not publishing stories with offensive or pornographic content. And, of course, you couldn't just write for any fictional universe, merely the ones that Amazon had licensed. It should not come as a surprise that the reaction from fanfic authors was negative, who felt that it was a needlessly restrictive and potentially exploitative arrangement, and the service was shut down in 2018. But all this raises a question. Shouldn't there be a space for fans to share their own creations based on another's work? Human beings have been adding to each other's stories ever since we began telling them, and characters such as Robin Hood and King Arthur are constantly being adapted in new and varying ways. Knowing this, it seems rather stifling that a rights holder can bar others from using their works even long after the original creator has passed away. The United States Constitution states that the purpose of copyright is to promote the progress of science and useful arts, but in the present day, copyright has become a means by which corporations act as the gatekeepers of our culture. When Disney told a grieving family that they could not use the image of Spider-Man on their son's gravestone, it's obvious that something has gone terribly wrong with our notions of intellectual property. The law should serve the people instead of being used as a cudgel by the strong against the weak. Surely there can exist some happy medium between respecting creators' rights to their creations and fans being completely barred from ever using those creations themselves. But what do you think? Let me know in the comments. Until next time, everyone.